it was a much celebrated unanimous decision by the Supreme Court of Canada last week. The court killed a constitutional challenge by Quebec over Bill C-92, a federal law that recognizes First Nation, Inuit and Métis jurisdiction over children, youth and families. For more on this, we're joined by our Truth and Politics panel. Carrie Benjo is the editor of Eagle Feather News, and Niigaan Sinclair is a columnist at the Winnipeg Free Press and with the University of Manitoba. Carrie, Niigaan, thanks for being with us. Niigaan, starting with you, why would Quebec challenge this right to have control over the children in our communities? Why is this a significant ruling?
Well, there's three main reasons. One is the provinces continue to see us as a revenue source, and when we get control over the lives of our children, they lose that revenue, particularly from the federal government. The second is that it's a jurisdiction issue. They see that First Nations governments aren't real governments, and that dealing with them more like municipalities or just not governments at all. And then the third issue is that there is an ongoing misunderstanding by the provinces, that's my optimistic word, to want to quash, ignore Indigenous rights. We see this in Saskatchewan, particularly a little bit in the previous government here in Manitoba, absolutely in Alberta and Ontario. But the real challenge is Indigenous rights when it comes to Quebec. You know, when Quebec wants to argue for it having special status under the Constitution, it doesn't. Going all the way back to the constitutional talks in Beach Lake, Charlottetown, it's not in the interest of Quebec for Indigenous peoples to continue to talk about their rights and have them recognized by the federal government.
We'll pick up on that in a second here, but Carrie, how do you think this decision will affect Indigenous children, especially those in provincial care?
I think right now we're not going to see a significant change because in order for, First Nations to take control, they need to have the space to bring the children home if ideally that's what they want. And when there's such a housing shortage on reserve and a lack of infrastructure, many First Nations don't have the capacity to bring the children home. But what this legislation does is it gives them the means in which to do so. Now they can work towards, building whatever they need necessary to bring their children home. And I think ideally that's what every First Nation person wants, is to have, be able to come back to the community, be able to rely on their family, their extended family, those resources to help raise their children and move back to that traditional child upbringing that, is so ingrained in our culture.
Now, Niigaan, you mentioned Quebec there, and they said that their argument was never with Indigenous peoples, but with the federal government. Do you think that's the case?
Yeah, that's exactly my point, is that Quebec continues to want to have special status under the Constitution, going back all the way to Confederation, really, 150 plus years. And Quebec, by wanting those special status, particularly for language and culture, but then also the other bigger issues around land and resources, Quebec is not in the business of trying to have Indigenous peoples articulate and have our rights affirmed. And continually, Quebec wants to resist that and to have it recognized by the federal government, not just in C-92. I mean, that's just a step in a much larger process. C-15, bringing Canadian law in concert with the United Nations Declaration on the Rights of Indigenous Peoples, is really a nightmare for Quebec in wanting to articulate bigger control and even the issue of sovereignty. I mean, we think back to the days of Lucien Bouchard and saying we're going to separate from Canada, and First Nations going, we have a choice on who we will join, Canada or you, in that new endeavor, and going, Quebec doesn't want that kind of conversation to really gain any momentum.
Carrie, do you think that this decision means that the Supreme Court of Canada might be more willing to accept that Indigenous peoples have inherent rights, not just over child and family issues, but maybe other big issues such as control of natural resources?
Definitely. I see this as a positive move forward. I think when we go back to the signing of treaties, one of the things that was mentioned was learning the cunning of the white man. And I always come back to this. Cunning of the white man doesn't necessarily just mean education. It means gaining that knowledge and that understanding of the institutions that created the system that we're in now. If we're not at those tables where decisions are being made, policy is being enacted, then our voice is left out, and we don't have say on what is happening. But now we're in a space, in a place where we are at those tables. We have our first First Nations premier, in Manitoba. So we are coming to the table. We are in all these spaces now, and it's so very hard to ignore us and put us aside. And we are using their laws to reaffirm what we have already always known.
Carrie and Egon, we'll leave it there, but appreciate you both taking the time again this week.
Yeah, much thanks.